The member for Wright.
Thank you, Speaker, and I indicate from the outset that I'm the lead speaker for the opposition on this bill, and also that the opposition is supportive of this bill, and I don't intend to take up much of the House's time this morning speaking about it or making any kind of exhaustive contribution on it. But I will just place on the record that when an act like this one is completely rewritten, which was the case with the Education and Children's Services Act 2019, which replaced both the Education Act of 1972 and the Children's Services Act of 1985, there are usually some unintended consequences which arise from such a large change to some pretty significant acts like those two. So this is not, I think, any great surprise that we find ourselves here to tidy up a few of those unintended consequences that occurred. And I know that the Education and Children's Services Act had been worked on by those in the Education Department for a number of years. A lot of work had gone into that bill, and early iterations began when the member for Port Adelaide was still the minister. And I thank the current minister for continuing that work and for the constructive way in which he engaged with the opposition and myself through that process. And I think what we came up with in the end was a good compromise. And I've received a briefing from the department. Thank you, Minister, for arranging that. And I accept what the minister has outlined in his second reading speech on this, that the changes that are being considered in this bill are largely legal, technical, consequential, dealing with pretty heavily operational kind of issues and in need of a pretty simple legislative fix, which we will support. I will just conclude my remarks by flagging with the minister that I'll just ask a couple of questions if we are to find ourselves in the committee stage. But as I said at the outset, Speaker, the opposition supports this bill.
The Minister for Education. As the minister speaks, he closes debate. The Minister for Education.
Sir, I thank the opportunity to again commend this bill to the House. I thank the member for Wright for his comments. I think that's one of the best speeches by a shadow minister on a bill that I've ever heard, and I commend him for his approach. It's genuinely been the work of many hands over an extended period of time to reform the legislation in the Education Act and the Children's Services Act, as the Shadow Minister identified. I don't think there's too many examples of reforms of entire pieces of legislation, let alone two big ones, where there hasn't been what are sometimes referred to as rats and mice pieces of legislation that follow. Usually you can pick them by the term miscellaneous being in the title, and these wrap up those issues. That's not to say that these aren't important issues, but as the Shadow Minister described them, they are operational issues, they are unintended matters, and they are no reflections on any of the drafters or the legislators who provided the work to get those massive reforms through. There are thousands and thousands and thousands of pieces of information in reforms of entire acts such as these, and there's a very, very small number of unintended consequences that are able to be wrapped up in legislation such as this. Happy to clear up any questions in the committee stage, and look forward to this bill's uncontroversial passage through the Parliament. I thank the opposition once again for their support.
There we go. The question for the House is that a bill for an act to amend the Education and Children's Services Act 2019 be now read a second time. Is it seconded? Yes, sir. Put the question at once. Those opinions say aye. Against say no. It's carried. The Clerk.
A bill for an act to amend the Education and Children's Services Act 2019.
Is it the will of the House to go into committee?
Hey everyone, we have no amendments on file, so if you'd like to let me know where the first question is. Member for Wright.
Clause 6, Chair, which is the insertion of section 26A.
Okay, thank you. So I put clauses 1 to 5, all inclusive. All those in favour, is this what I'm doing? Yep. All those in favour say aye. Those against? Carried. Member for Wright, sorry.
Thank you, Chair. And on the insertion of section 26A, Minister, I note there it talks about the clause requiring that the Minister conduct consultation before making such a declaration. I was wondering if the Minister could give us just a brief outline, perhaps, of who that consultation might be done with in the event of a declaration.
If the member's happy for me to provide some brief background in the lead up to that, I think the intent will become slightly more clear. So standalone preschools and children's services centres that were formally registered under the Children's Services Act were continued under the Act in a way that preserved their model of governance, whereby the preschool or service in itself is itself an incorporated entity overseen by a governing council that is not incorporated. The Act has introduced a new model of governance for standalone preschools and children's services centres that is similar to schools, whereby a standalone preschool or children's service centre can be established by the Minister with an incorporated governing council. So this clause will provide a means of transitioning preschools and centres continued under the Act from their current mode of governance to the new model of governance without the need to formally close and re-establish the service. A standalone preschool or children's service centre would only be transitioned following consultation with the preschool or centre and full consideration of any relevant issues associated with the transition. There's no immediate intention, and I think this is a useful for the member's specific question too. There's no immediate intention to make any declarations under this section. Any declaration in the future would only occur after consultation with the governing council of the standalone preschool or children's service centre, as the case may be in accordance with subsection 26A2. Not that I anticipate necessarily needing this. I think this is a future-proofing clause. But were I the Minister, I would probably err on the side of a broader consultation rather than just using the letter of the law to have it as the consultation being with, I've consulted with one person, therefore that's not consultation. I think explicitly the governing council is involved, but as Minister I'm sure the opposition would agree you take into account the views of anybody who's got a point of view.
Member for Wright, do you have another question?
No further questions on that clause. Thank you, Chair.
What's your next clause, sir?
9, Chair, insertion of section 56.
Okay, thank you. So I put clauses 6, 7 and 8 all inclusive. All those in favour say aye. Those against, no. That is carried. Member for Wright.
Thank you, Chair. And on this clause, Minister, if I could play devil's advocate just for a second in regard to the Minister's powers to declare a school a special purpose school. If we were to, for instance, to take the example of Springbank or a school whose future has been uncertain at different times, what is there to prevent a Minister from declaring a school like Springbank, I guess, a special purpose school, and therefore stopping mainstream enrolments and having that enrolment process change?
So, firstly, the amendment of this section will provide a simple way for the Minister to transition an existing school to a special purpose school under the Act without the need to close the school first, dissolve its governing council and re-establish it under the Act. It's anticipated that this is one where the school would want to do it, the governing council would want to do it, but it would mean that you don't then have to close the school in order to then reopen it. So the mechanism would involve, for example, so what is a special purpose school I think is worth putting on the Hansard as well, because while ministers and shadow ministers and former staff in senior positions in the education might be familiar, I suspect many aren't. So a special purpose school is a school established for a particular purpose, for example, the provision of education to children detained in training centres or the provision of education to children in hospitals. There's a number of other really specific sort of things that can be found in our education system. There's some wonderful work being done in them. So the provisions allow the governance arrangements and other relevant provisions of the Act to be tailored to the specific needs of the schools. We'd be talking potentially about a very small number of schools. So prior to any transition, the Minister or the delegate would need to make appropriate effort to consult with the governing council of the school. Now, all schools have governing councils or in one mechanism or another. So that governing council, which in almost all cases, if not all cases, has a significant parent body as well as staff and potentially community representatives, have the opportunity to have input into that. The Minister must consult with the governing council of the school before making such a declaration, and the regulations may make further provision in relation to declarations under this clause. So obviously that's the purpose, that's the intent. We don't have any particular items in mind. Again, this is one where we're looking to future-proof the legislation. Were such a case to arise, then this will enable such a transition to be made without having to go through the process of closing a school. That process, in the example the member cites, is one where we explored whether that would be beneficial to the community. And while that process did indeed return a result that would have left the closure of the school available to me as an option, as the member will recall, I certainly formed a view that the community and the students there were best served by keeping that school open, and that's a view that I will maintain throughout my term in this position.
Right.
Further questions on that clause?
What clause is your next one, sir?
24. Thank you,
24.
Chair.
We're really rocking.
Big jump there.
Okay, so I move clauses 9 to 24 inclusive. All those in...
I think he's questioning on 24.
Oh, 9 to 23. Sorry, I got ahead of myself. Nearly cut you out, member for right. Clauses 9 to 23, all inclusive. Those in favour say aye. Those against say no. That is carried. Member for right.
Thank you, Chair, and thank you, Minister, for that answer. Clause 24 talks about deleting the words "and without negligence" in regard to protections, privileges and immunities, and I accept if the Minister needs to take this on notice. It's a little bit more specific than my previous questions, but I'm just wondering why those three words "and without negligence" are going to be deleted from that subsection.
Thank you. I'm happy to provide an answer. And so Clause 24 of the Act amends Section 138 to remove specific protections from civil liability provided to the Chief Executive, an authorised officer or any other person for acts or omissions done in good faith and without negligence in the exercise or purported exercise of functions or powers under this Act. Clause 24 also amends subsection 138(2) to remove the terms "without negligence." This will ensure a member of the governing council or affiliated committee is protected from civil liability for acts or omissions done in good faith in the exercise or discharge of a power or function of a council or committee, whether or not the act or omission was negligent. The protection from liability set out in subsection 138(1) did not feature in the Education Act 1972, given that the Public Sector Act 2009 already sets out relevant protections from liability for public sector employees and other relevant persons. I'm advised that the matters set out in subsection 1 are not required to be included in the Education and Children's Services Act 2019. In respect to the proposed removal of the terms "without negligence" from section 138(2), which provides protections from civil liability to members of governing councils, this will revert to the situation which existed prior to the commencement of the Act. So we are basically returning to the same level of protection that existed prior to the new Act, which I believe was the original intent.
Member for right.
Any further questions on that clause or any other clause? Thank you, Chair.
Thank you. So, no.
So put 24 and 25
Okay.
and then put the title separately.
Okay, so I put clauses 24 and 25 as they are unamended. All those in favour say aye. Those against say no. That is carried. So I put the title of the bill as the Education and Children's Services Miscellaneous Amendment Bill 2020. Is that agreed to? All those in favour? Aye. Those against? No. That is carried. The committee has considered the bill and made no amendments. Minister.
Sir, Mr. Acting Deputy Speaker, and a fine position it looks right now. I move that the bill be read for a third time.
Is that seconded? Thank you. All those in favour say aye. Those against say no. That is carried. Clerk.
A bill for an act to amend the Education and Children's Services Act 2019.
Minister.